Start. Para. Accused Lakshman stood prosecuted for charge of an offence punishable under sections 302 and 201 of the IPC 1860. The prosecution case in short is that on 1/1/2019, the informant (PW2) Ramakant lodged a report that he has been serving as a police patil of the village. While he was at his agricultural land, he received a phone call from Vaibhav at 8 am that his sister-in-law was dead as someone killed her. On that, the informant along with others went to the spot and found that the door of the house was open and the dead body of Renuka was lying in the hall. There were injuries on the dead body, including on forehead, and there was blood on her lips. The cloth below her dead was blood-soaked. Husband of Renuka, the accused, was not at home, and his brother Sham was alone present there. Para. The report (Exhibit 60) further narrated that on collecting further information, brother of the accused named Namdev told that the accused had talked to his son on 31/12/2018 at midnight. Another brother named Sham told that on night of the 31/12/2018, the accused and his wife Renuka were alone at their home. He further told that as on 1/1/2019 at 7 am, accused and his wife were not seen outside of the house. He went to their home only to find that in a plastic bag something was stuffed. He, by means of razor blade, broke the string with which the bag was tied. They found the dead body of Renuka suffered inside the bag. On that, he cut the rope with which her limbs were tied and laid the dead body there. Sham further told that he did not know when the accused went out at night. The informant lodged a report stating above mentioned aspects by expressing his suspicion that on unknown reason the accused killed his wife and went somewhere. On receiving the above mentioned report, Police Station Shirur on 1/1/2019 registered an offence wide crime number 1 of 2019 punishable under sections 302 and 201 of the IPC, and the investigation in used. Para. In the investigation, a dog squad was pressed into service and the report was obtained from the squad, which was inconclusive. A letter came to be issued to a medical officer. Inquest Panchanama came to be prepared. Correspondence ensued for getting the post-mortem examination conducted. After such examination was conducted, the dead body was handed over to the relative of Renuka by obtaining an acknowledgement in that respect, provisional certificate, and then post-mortem examination report came to be obtained. Spot Panchanama came to be prepared. Seizure Panchanama of clothes of Renuka came to be prepared. The video recording was made. A hash value was calculated and the certificate was prepared. The memory card was seized. The statement of witnesses came to be recorded. The certificate in respect of ailment of the Renuka came to be obtained. Para. Accused made disclosure statement and pursuant to it his clothes came to be seized As per Memorandum Panchanama, the memory card came to be seized. As per the seizure Panchanama, the documents including log book came to be collected. The hash value certificate came to be prepared. The extract 8A of the spot of incident came to be obtained. The Muddemal property and CA samples viscera came to be forwarded for chemical analysis. Remaining statements came to be recorded. In the investigation, it revealed that from the first delivery of a body by Renuka, she had been suffering from incurable disease. The accused had suspicion that due to Renuka, he got infected of the same disease. On that suspicion and also on suspicion on fidelity of Renuka, the accused killed her. The accused stuffed her dead body in a bag and tied it with a rope and thereby tried to destroy the evidence. Para. After completion of the investigation, a charge sheet against the accused came to be presented. The learned judicial magistrate of the first class court number 2 Nilanga committed the case, it being triable exclusively by the Court of Session. My learned predecessor framed the charge Exhibit 6 for the offence punishable under sections 302 and 201 of the IPC, to which the accused pleaded not guilty and claimed to be tried. The examination of accused under section 313 (1) of the CRPC 1973 came to be recorded White Exhibit 144. His defense is that of denial and false implication in the crime. According to him, he had been to Mumbai along with his brother and both sons to attend a spiritual discourse satsang on 31 date. While returning by a travel bus, his son received a phone call at Latur that his mother died. He doesn't know in respect of the case. The following points arise for determination. I record findings thereon for the reasons stated thereunder. Stop.